Good afternoon, everyone, and welcome to this new episode of The Future of Europe proposed by the students of the Catholic University of Lille in Masters of International and European Law. One key topic the EU must face and will always face is migration. Today we are welcoming Thais Daramont, with whom we will go through a judgment of the Court of Justice of the European Union on family reunification of refugees. Good afternoon, Thais. Can you first present the case?
Good afternoon, thank you for having me. First, I would like you to imagine that you are in a country at war and you must let your minor children run away in another country. They survived the trip and finally arrived in Germany, where they obtain a refugee status. It comes a time where you can join them and you ask for family reunification, a right for non-EU nationals to bring their family to the European country in which they are legally residing. However, it is refused to you on the grounds that they had come of age during the procedure. Those are the facts of today's case. The Court of Justice is called upon to answer two questions. The first concerns the interpretation of the minority condition, and the second question concerns the relevant factors to be considered in assessing the condition of effective family life.
Okay, this is interesting. How was the case brought before the Court of Justice?
So we have two Syrian nationals arrived in Germany in 2015. They were granted refugee status and have had a residence permit for 3 years. And the German embassy refused the application for family reunification of their parents on the grounds that they have come of age during the procedure. The Berlin Administrative Court orders the issue of the visas for family reunification. And however, the Federal Republic of Germany lodged an appeal, and the Federal Administrative Court referred two questions to the Court of Justice for a preliminary ruling.
Okay. What is the legal framework for family reunification? Could you explain how the court ruled in this case?
Yes, so the European Parliament adopted a directive in 2003, and this is the first set of measures concerning the conditions for the entry and the residence of third nationals within the European Union. And Chapter 5 contains derogations creating more favorable conditions for the family reunification of refugees. The court ruled based on the ground of the principle of uniform application of the European law. It recalls the principle of the uniform application to guarantee two elements: first, equality, and then the objectives of the directive. So first, equality. Equality here is not guaranteed because the interpretation of Germany is not in line with the one made by the court. So there is a breach of equality between litigants in Germany and litigants in other member states. So there is a breach of equality. The second point is the objectives of the directive. They are to promote family reunification and to grant protection to nationals of third countries and to promote family life. So it's favorable conditions for family reunification. And the interpretation made by Germany, is not in line with is not in line with the objectives of the directive, because the interpretation restricts the right since the procedures can be lengthy. So this is why the Court of Justice recalled the principle of uniform application.
Okay, so you said that this interpretation was not in line with that of the court. Did it previously rule on such a matter, or has it not?
Yes, indeed. Here the court is just upholding its own rulings. On the question of minority, the directive provides some elements for family reunification of refugees. So we have Article 10 that provides that in case of an unaccompanied minor refugee, member state must permit the residence of the refugee's first-degree relative in direct ascending line for the purpose of family reunification. Article 2 defines the concept of an unaccompanied minor. And then Article 5 provides that member states must examine applications for family reunification in the interests of the children concerned and with a view to promote family reunification. However, here German law interpreted those provisions by saying that an unaccompanied minor refugee must be under 18 until the end of the proceeding. So this interpretation does not comply with either the objectives of the directive or the requirements deriving from the Charter of the European Union. Refusing an application for family reunification based on this condition neither promotes family life, an objective of the directive, nor takes into account the best interest of the child, a requirement of the Charter. By considering a minority as a material condition, national courts would tend to extend proceedings to refuse the right to family reunification on the sole basis of this new majority. And this interpretation violates two fundamental principles of the Charter. First, the reasonable time of proceedings, and then the need for a child to maintain a regular relationship with both parents.
Okay, but in order to make a reference for preliminary ruling, don't you need to bring forward a new question that has not been judged already?
Yes, that is correct. That was made in a case law of the Court of Justice. But here the court uses the case at hand to provide a new interpretation on the condition of effective family life. This is why it is new. In Article 17 of the directive, it is provided that to assess the family life, national courts must take into account the relevant factors from each case. So it is not really clear which are the factors, and it does not provide how concretely assess this condition. So here, first, the court sticks to the case and then provides its new interpretation. First, the court argues 2 points to consider that there is nothing to indicate that the parties did not maintain an effective family life during the period of separation. First, the only separation cannot justify the absence of family life. A court cannot refuse a family reunification only on the basis of a separation. It makes sense in the way of family reunification is about bringing back together people who have been separated. And the second point is that reaching adulthood does not mean there is no longer family life. Then the court provides a new interpretation for the future cases. According to the court, to assess this condition of effective family life, national courts must take into account the intent to establish or maintain a family link rather than the actual existence of a family link.
All right, well, thank you for this very clear interpretation and explanation of this case. What do you think will be the future of family reunification? And how could the EU guarantee its uniform application in the future?
I believe that the legal framework of family reunification is clear and has been clarified over the years by the court. Indeed, it continues to apply its legal precedents and reassets its position by drawing up upon prior decisions. And to ensure the uniform application, it is like other areas of European law, the Court of Justice has the role to guarantee that national courts are correctly applying European law.
Okay, well, thank you very much. This was very interesting, and thank you for coming. See you in the next episode.
Thank you.